Okay, thank you. We will call to order the Wednesday, March 18th, 2026 regular meeting of the Aspen Pitkin County Housing Authority. First item on the agenda is roll call.
Were you in twice, Mike?
Shouldn't be.
Jackie?
Yeah, is your mic on?
No.
Is your mic on? Cindy? Thank you.
Jackie?
Yes.
Carson?
Here.
John?
Here.
Peter?
Here.
Christine?
Yes.
Tad?
Here.
And Jeffrey?
Here. Okay, great. What?
You can't sit up here. This is for the
I'm not
board
going
only.
to sit up here. Thank
Oh.
you. I don't want to sit up here.
They should have some in the back there as well.
Okay.
Maybe not.
All right. First item, we got any agenda amendments? And does anyone have any agenda amendments? Okay, hearing none, we'll move to public comment. So we will start public comment here. We'll go in the room first. I think we have a number of public comments today. So for anybody that would like to make a public comment, if you're in the room, please come up. You come up to the microphone, please identify yourself. We do have a 3-minute limit on time. If you are online, when we take those, we'll be asking you to raise your hand so that we can unmute you. So welcome. If you would, state your name.
Hi, Robin Whitland. I have been here a few times before, and I have been writing to all of you. So thank you for at least listening, to really discuss about whether or not you're going to at least consider what I have proposed about perhaps adding senior housing into the mix. Given the... Can somebody not hear
You
me?
just have to speak up. The mic doesn't.
I'm sorry.
Can't hear you.
Is it on?
The mic's on. They just.
Is it on?
It doesn't push.
Yeah, you're
You're
fine with that.
You're
She
fine.
can
Okay.
hear
Go ahead.
you.
Oh, okay.
She just needs you to speak up so she can hear.
Okay, got it. And I really started this whole process a few months ago and writing to you only because I read the articles in the paper about the empty housing that has been available, particularly the Aspen Country Inn. Otherwise, I've not worked. I've lived in town for 35 years. I've been involved in town for all that time, but I own a business and have never done any work in Pitkin County. So there's the rub, and you're right to have that, but I know you're looking at a number of different things now, given some of the availability. So I ask if you would consider what I'm proposing, just to add it into the mix of what you're looking at. So
Thank you, Robin.
that's my comment.
Okay. Thank you. Any other public comment? Please come on up.
I couldn't hear a word she said. Anyway, I'm talking about,
Could you just state your name?
oh, I'm sorry, Ruth Harrison.
Thanks, Ruth.
Talking about the, what do you call the last category that you have, the highest category. RO. Talking about the RO units. I think it's pretty demoralizing when somebody buys an RO and they can now relocate the kitchen, move the entry location, change the primary bedroom layout, replace all siding, replace windows, replace the roof, rebuild large deck, change front door location, add small room above the new door, add entry and deck trellises, and dug up the whole yard and then filled it in. They probably put, who knows what they put below. And they removed half of the siding on the wall and the sheathing on the plywood. How can you do that? It's pretty demoralizing. Hello?
You're asking for a response. I mean,
Yes.
that's City of Aspen. That's not right. Those are all zoning issues. You're talking about moving front doors, moving. Those are all remodeling. That's not.
This is remodeling for employee housing. How can somebody in employee housing afford to do that?
I mean, we have categories. They're the categories. If
How
they fit
can
into
somebody
the category,
in employee housing afford to do that?
Ruth, I
I don't care.
I don't know. That's a rhetorical
I don't
question.
I don't
know.
care if it's RO or not.
Okay.
How can they afford to do that? Why are they able to live in employee housing?
We look at income and assets at the point of sale, at the point in this case of buying. We do not have restrictions afterwards.
Right.
That's the answer. Yeah.
Don't you think you should? Don't you think there should be a cap? How much money and how many things you can change in your house? That guy could obviously buy a free market.
I don't.
I know. Nobody
don't
knows.
I mean, what I will say is today I actually went to. I heard from a presentation today that the average single-family house in Aspen is $20 million, and the median was 15. So, you know, I mean, I don't. That's not a policy that this board is considering, and yeah, I mean, I share your frustrations with people that have significant resources, but at the end of the day, it sounds like this property is getting a pretty significant upgrade at the expense that's not a taxpayer expense, and I don't know.
I don't either, but it's very demoralizing, and people are asking about it, and I just think you need to change the guidelines for what people in RO can do. It's ridiculous.
Thank you for coming in, Ruth.
You're welcome.
That's Ruth. Okay, is there anybody else that would like to make public comment? Looks like Tom has, Tom, you want to comment on that? Is Tom,
I think he's muted.
he's muted right now.
He should be.
What?
I have asked him to unmute. I have done it. I know that that's all. He's still got it muted.
Yeah.
Tom, can you turn on your speaker, please?
Can you just unmute him?
Oh, he just unmuted himself.
Am I unmuted now?
Okay, Tom, we can hear you.
By the way, that guy moved in 3 years ago. So he must have made
You
a
have
lot
me
of
locked out.
Okay, yeah, that's what I figured. Tom, go ahead.
I was just gonna, hi Ruth, this is Tom. I was just gonna respond by saying that the answer to that is very simple. In RO housing, you're not limited by income. And by definition, that's what RO housing is. You can get in, you just have to be a full-time resident working in Aspen or Pitkin County, and otherwise the financial limits don't apply. So that may or may not be a good idea, but we do have some units that are in that category, and the purpose of it was to basically provide some housing for people who can't qualify for the category housing, but also can't afford the $15 and $20 million houses that Carson was referring to.
Don't we have like 800 RO units?
What we do, you have to take into consideration Aspen Village.
Right.
I'm sorry, Aspen Village, Lazy Glen, a lot of those are all RO as well. So that's added into the mix of all RO units, those those what used to be mobile home parks.
Thank you, Tom. Thanks, Tom. I think you need to change that, though. I think it's it's upsetting to people, because this guy comes in, he's been there 3 years, maybe 4 years, I doubt it, and he just redoes the entire place. And he has all this money, he switches his cars, his 2 cars every year. I mean, it's just upsetting to people in the neighborhoods. So, Thanks for all you do, Tom. Tell your kids I said hi.
Thanks, Ruth.
You're welcome.
Okay, is there anybody else that would like to make a public comment? Okay, hearing none, we will close public comment and we will move to the Board of Directors' comments. And I think everybody is here in person. So Jeffrey, we'll start with you.
No comment. Good afternoon.
Comments. Good to see you. Ted, welcome.
Yes, thank you. Happy to be sitting in the seat as the lead for BOCC. I know a lot of you already. I can keep it kind of brief, but hi, Jackie. I'm very familiar with APCHA. I've lived in APCHA since 2003. Most of my friend network in town is in APCHA, so I'm kind of excited to literally have a seat at the table. And look forward to learning a lot from all of you.
Thanks.
That's all.
Christine.
Welcome to TED. We're happy to have you here. Thrilled to be on board with you. So that's all.
Same. Excited you're on board, Ted. Congratulations. I wanted to ask the board if at some point we can explore what the turnover is in APCHA. And by that I mean the number of new entrants to the program each year and the number of residents that move beyond APCHA each year. Just reflecting on some of our recent policy discussion and regulation changes, I think it'd be super helpful to understand if we're moving in a direction of more turnover or less turnover, and I think there is a healthy amount of turnover. I don't know what that is, but right now we don't know what that is, and I think it's important for the community and the health of the program that there is a healthy amount of turnover, and that would be helpful in the context of some of the policy changes we decide on. And I also want to comment, or I'd love to know regarding Robin's inquiry, how many vacant units we do have. And then with regard to Ruth's comment, I think it is, for our own education, worth looking at what the distribution of our total inventory is between categories in RO, rental, and ownership housing. I think it would just be worthwhile to have that discussion. And I know Cindy answered last time that it's very rare that these units change category. So if our inventory isn't really changing, but the program is, I'm just curious if we feel the distribution that we have makes sense.
Okay. Thanks, Peter. John?
Just wanted to welcome Ted to the board as well.
Thanks,
Jackie.
Same.
Okay, and I don't have anything to add other than the welcome to Ted. So we'll go to Executive Director updates with Matthew.
Good afternoon, everyone. Matthew Gillen, Executive Director. Truscott 2 is full for the first time in a long time, which is great. And Aspen Country Inn, we have 4 vacancies, of which 2 of those vacancies we are qualifying people to. And we just had our communications meeting this week, so we're going to continue with one more round of Spanish language radio ads for those 2, and then we're going to pause and see how we're doing in the summer if we want to redouble our efforts in the summer to advertise. And just for the board members who are new, I'm singling out Truscott 2 and Aspen Country Inn because those are our LIHTC units. So those are the ones which have a very strict income cap on them, which we have trouble filling historically because the wages in Aspen are so high in Pitkin County. But we've been putting a lot of work to advertise those units, and we've had considerable success. So we're going to keep plugging away there, and I'll keep you updated.
And we also have reduced the number of hours required to qualify for those units, and the LIHTC income categories are set. They're federal level versus everything else for APCHA is done on a Pitkin County basis. And then, so do you know, just sort of ballpark, I mean, those units that are vacant, I mean, how long have we had
So-
those vacancies?
Let me go through it and then I do have that in an email.
Okay.
Let me pull that
Great.
up and I can get that to you.
Great.
And then the new website should be coming on board hopefully next month. Meg's been putting a lot of work into that, going back and forth. So again, to those new board members who are on the APCHA website and thought, this doesn't look very good, it's going to look much better soon. So we're putting a lot of work for that. Meg wanted me to highlight a couple HOA education series we're having. We're having one on Thursday, March 31st, and that's about insurance claims. We're going to have a coffee morning on Thursday, April 7th at 8 in the morning at APCHA, and we'll make sure you all are invited, or at least have on your calendar, to both of those. The HOA education on insurance claims, that will be by Zoom. We're trying a bunch of different times and formats to give people opportunity to come in there. So if you can't make it in person, we'd love to see you by Zoom. And then in February, we had a education series for HOAs, and that was with the city and county permitting departments, which was great. And that was for HOAs, and it was a very robust and insightful conversation about how to do permitting with the city and the county. And we're looking to do more of those collaborations with other city and county departments to benefit HOAs and individual owners. Okay. Further, the newsletter is coming out this week, and we had a column in the paper on Monday, and we managed to get that column moved up a few days so we could give people plenty of notice about the reg changes, the reg discussion you're having this afternoon.
Great.
I'll put a memo in the packet for the next meeting. But at the end of last year, the board, there was a lot of discussion about the possibility of HOAs pooling procurement, I don't know, for roofs or windows or whatever, and then maybe even going through the City of Aspen procurement department and sending out an RFP. Staff put a lot of work into that with the procurement department, and including discussions all the way up to the city manager, and the answer is no, it cannot happen that way. There are too many liability exposure, and operationally it'd be very difficult. We put a lot of work into trying to make it work, but ultimately it does expose the city to too much litigation risk. The city, in various cases, is being sued for decisions they didn't have any part of, so that would fall under that. So, but I just wanted to make it clear to the board that we did hear that, and we tried really hard to figure something out, but we couldn't. And I'll put in a memo in the next packet just to document that, so we remember what happened in the future. And then I had one other thing, and again, this is asking for direction from the board on what you'd like to discuss. APCHA's already getting concerned inquiries about the airport closure in 2027. I was at the ACRA breakfast this week and last week, and businesses are very concerned. They feel like they're not sure what's going to happen, and it's not just people who work at the airport that's going to have a lot of impacts we don't even know about. There is a provision in the APCHA regs for people can ask for a temporary waiver to work hour requirements. APCHA considers the reason for the termination, the availability of other employment, whether the person in APCHA's discretion is actively looking for employment, and we do that on a case-by-case basis. But the question for the board is, would you like for us to explore a more general or blanket waiver of the work requirements for 2027? And all you have to do now is sort of give me a consensus that you'd like to explore it, and we can get some more detailed discussion on the agenda for a future meeting.
Anybody have any thoughts on that?
I believe something similar happened during COVID.
It did.
Yeah.
Yeah.
So that would be kind of the model we'd be looking at for Yeah, we were thinking just 2022.
So during COVID, the consensus with the board was that, I mean, nobody on the board, extenuating circumstances, nobody on the board was in favor of anybody who was unable to work because of COVID. Nobody was wanting to evict them. There was very much an attitude of grace. There, however, I don't believe was any sort of a formal policy.
Okay.
And I think it kind of ended up being, for the most part, not really an issue. So anybody have an opinion on this?
I think if APCHA could reduce uncertainty for airport employees or businesses that are impacted, restaurants that may face a furlough or some other, action to ease the concerns of the community, and seeing leadership coming out of APCHA, I think would be an incredible move at this point in time, even if it's in the next meeting. So it would be one of the first organizations that's proactively said, we know there's a closure coming. We know it's going to impact employees. Why would you want to add this level of stress to someone's life on top of, for example, a furlough from, SkyWest?
Okay, we'll do some thinking and we'll come up with some policy suggestions and ideas for a future meeting.
So this pertains to renters that requalify every 2 years and people on their affidavits,
Right.
which would be,
Right.
we do affidavits every 2 years.
And 27 is an affidavit year, but that would be looking at
2026.
2026 numbers. So this would be the hours worked in 27 during the airport closure.
Would show up on the
28.
28.
I mean,
So we have
29, yeah.
29.
But it would be just to give people some assurance that we're thinking about it and we have a policy and we're not just going to wing it. That's just the thought.
Yeah.
Great, okay.
I would just add making sure there's some guardrails in there as well,
Yeah.
so that there's not abuse of
We will
the system.
Documentation.
Yeah.
we'll come to you with some ideas and make sure you're involved in the discussion as we develop something.
Yeah, I'm not trying to be unsympathetic, but I know it's come up in county and city meetings, where are we gonna get all these employees or these workers for the airport, the lumberyard, all the development, snowmass, the base, lift 1A, so it seems there's gonna be a lot of work, but it's not in the industries I understand people work in, so for what it's worth.
Great, and that's all I have this evening. Thank you.
Thank you, Matthew. Cindy?
Just to reiterate that we have pulled the ad for the 2 bedrooms at Truscott Phase 2 because they have been filled, or they're really close to being filled. We have still listed an Aspen Country in 1 bedroom unit, but we're working really close and getting that filled as well. Right now, we don't have any new units coming up for sale, but we should, not this coming week, but the following week, we should have a couple coming up. So again, sign up for notifications.
Thank you, Cindy. Okay, we'll move to the consent calendar. One item, minutes of the February 18th, 2026 regular meeting. Is there a motion to approve?
So moved.
Motion from John, second.
Second.
Second from Peter. Any discussion? Amendments, changes? Okay, hearing none, it's a roll call vote.
Carson,
Yes.
John,
Yes.
Peter,
Yes.
and Ted.
Yes.
Who am I missing?
Scott?
Scott's out.
Jackie?
Oh, so Jackie. Great.
Yeah.
Thank you.
Okay, great. Motion passes. Okay, well, now we're going to move to the first reading of Resolution 2, Series 2026, adopting amendments to the Aspen Pitkin County Housing Regulations and schedule the April 15th, 2026 public hearing. So we've got a number of changes here. Who's going to lead us on this one?
Bethany's
Bethany?
Bethany's been homesick, so she assures us she's good enough to join by Zoom, so we'll see, but we'll step in if.
I'm here.
She is.
Sorry, all, I'm not with you. Karen, you need to turn on my video too. So, I apologize. I didn't want to get anyone else sick. So I'm going to try to do this remotely. And Cindy or Matthew or Emily is at the table too. They can jump in if need be, or if I lose my voice. So Carson, if it's okay with you, I'll go through them one by one.
Sounds great.
Great. So the first is changes to unit appreciation and rental increase calculations for APCHA ownership and rental units. Staff is proposing a flat 3%.
Bethany,
Yeah.
do you want to share your screen, or do you want us to try to put that up?
Cindy, I have no control. I
Got it.
can't turn my video on. I can't.
Okay, we'll do
anything.
it.
Sorry, Bethany.
We'll get it done.
We did that after the
Yes.
takeover
It's totally fine.
from last week.
So currently, staff adjust rental rates and home appreciation under 3% or CPI, whichever is less. And staff is proposing we go to a flat 3%. That still is a simple appreciation. So it would be a simple appreciation for ownership units of 3%. And for rental rates, every year the rental increase could be 3%. Staff is proposing that this would be a great change due to the simplification of the process, both from a landlord perspective, not knowing what the new increase will be year in and year out, and from an owner's perspective, having a clear understanding of how much their property will increase from year to year. The 3% or CPI calculation is often quite confusing and hard for folks to understand, and we just think the 3% is not going to increase home values drastically. We ran the numbers. We've shown that before in our last meeting, and we think it's a fair place to be. Over the last 20 years, inflation, year over year, inflation was about 2.6%. So it's a slight advantage over the 3% or CPI, whichever is less, but it's not drastic. We also have had issues in the past 9 months, 6 months, 7 months, under getting actually CPIs published on a month-to-month basis. We had a period of 3 months where the government did not publish them, and then they've been consistently coming out late since then. So we'd really like to take control of this with a flat 3%. So I'm happy to answer any questions.
Just a quick question. So in order to get this, if this were to pass, it would require signing a new deed restriction? Yes?
Yes.
Okay.
It would be a new deed restriction or a new buyer.
Okay.
The other option, Carson, is if the deed restriction says that it's in effect, as the regulations change, we would be putting it in the regulations, so it would be there.
Okay.
But the goal would be new deed restrictions.
Any discussion on this one, or can we move on?
I think this is one of those things we've talked about for a while, and it makes perfect sense.
Do you want feedback from our council on each of the? We took these to council, or is that sort of? I know Matthew was there, so do you have that, or do you want me to tell you? The council was okay with this, but there was a suggestion about 3% or CPI or whichever is highest. So if the CPI was above 3%. Well,
Yeah.
and I think the point was maybe
If inflation's that high.
Or higher.
Or higher than that.
Right.
Jen, do you run into the problem Bethany was describing where
Well-
sometimes they don't report CPI and
So I think, I think, right, one of the reasons for doing this is that we don't have the data and that it is an unknown. And so we're removing an unknown. And while I hear you on the 3%, I hear council on the 3% or higher, my personal opinion would be, in a scenario where we did have 10, 11% inflation like has happened in the past, I hope that never happens again, but wages are certainly not going to grow at that same
Right.
rate, and so then that inflates the value of the house, and so then we have a whole nother problem. So, personally, I would be in favor of just sticking with 3%, but.
So how does it work though for the deed restrictions that don't have the verbiage about as regulations change?
So they would still be under a 3% or CPI, whichever's less.
until they potentially refinance or what have you, sell. New
Or
deed restrictions
they
on.
have the opportunity to go under a new deed restriction at that point in time. And because there are some that have a flat CPI, there are some that are 6% or CPI, whichever is less, which they probably would not go under a new deed restriction. But this gives them the option, and I would still think that most people would still want to opt to go under an updated deed restriction.
And also going under a new deed restriction would give them access to the more generous 10% capital improvements allowance, which the board approved last year. And also in our communications discussion this week, if the board agrees to this improvement to the deed restriction, we are going to be doing a aggressive communications plan to get people on the new deed restriction.
Great. Any other comments on this? Are we ready to move on? Anything from the county? Jeffrey, Ted?
We had a discussion about it yesterday, and the BOCC was in support. There was, some questions, but I think we see the benefit of it.
Great. Okay, Bethany, let's move on to removal of longest work history from tenant selection process for APCHA managed rentals.
Great, so as Carson just said, this is for APCHA managed rentals only. There's about 270 of those. It's Aspen Country Inn and Truscott with a few over at Smuggler. But staff, as I think we spoke about this in the January meeting, of those who expressed interest in the units, average work history was offered to someone, with about 13 years. The max work history we've seen is 41 years, and the minimum has been 2. But the average that we're seeing is about 5 years. Staff is proposing to remove the longest work history from being the order in which staff offers units. It has proven to be an incredibly cumbersome process. People say they have a certain work history. When they actually try to document it, they can't prove it. So then we have to go down to the next person to try to figure out who it is. And so it's taking a lot longer to fill the units while we work through this list. Staff also feels like we field a ton of phone calls from folks just trying to find housing and being very disheartened when we tell them, well, I'm sorry you've only been here a year, but you can apply, but you probably won't end up with a unit because it goes to the individual with a long work history. And they're calling us when they're trying to get to town to try to find housing, and they can't. They haven't been in town to know where things are, to know that there's Castle Ridge and Centennial and all these different properties out there. So we do think, both from a staff administrative burden and from filling units in a quicker and more time-efficient manner, removing this would be wise.
Okay. I know there's going to be comments on this one, so Jeffrey, Ted, take it away.
Similarly to the first one, we did support this. There is concern about not honoring veteran employees, but it is pretty onerous to have to do this research for that far back. Was it ever discussed to do a shorter period, like not your entire work history, but maybe a period that was more easy to verify? Or was that still too hard on staff? Is that?
I mean, I think we would see that as still quite a lot of work. And then if you had, if it was 10 years, you had 2 people at 10 years, you still have to be coming up with a lottery system between those. So, we propose going straight to a lottery system for these rentals.
Okay.
Ted, were you thinking like 2 years or?
Well, I'm just looking at, the info in the packet where it says the longest work history is 41 years, and I realize that's a lot for anyone to be able to verify. You know, we just hear from both. I can see the perspective of the long-term local and the new arrival. So I was just curious. I haven't been in the discussions that got us to this point. But that was something that we discussed yesterday at BOCC. We did support this,
Okay.
but that was just a question that came up.
Okay. Christine?
We were in support of this.
Yes?
Yeah.
Okay. Peter?
I think it came up during your council meeting that the 207 units is only a fraction of the
Yeah.
1,400 units, so
Right.
it's a small impact to the overall.
Okay. Jackie?
I'm in support of it.
Okay. Great. Let's move on to removing rental requalification income units.
Great, and this is a slight change from our February meeting. Staff went back to the drawing board and really listened to what you all thought about and stated. And so the regulation that we're proposing is that at requalification, a household could qualify at one category above the unit. That removes the percentage of 150 that's currently in the regulations. We talked about 200 or 250% and some other amounts in the February meeting. And staff really felt like the cleanest way to go about this was to allow people to qualify just one category above, just like they're allowed to bid in an ownership unit. And that would be both fair and easy to understand and administer.
Okay, great. I'll go the other way this time. Jackie, do you have any thoughts on this?
So it would remove the 150%.
It just would, it would just be one category higher. So you would requalify and you would have to meet the next category up.
I mean, based on what you guys are seeing, do you think that? Could you check that mic in front of you? Sorry. Based on what you guys are seeing with the conversations of people who are saying, turning down bonuses and things like that, that brought this up, do you think the amount of increase that those bonuses and pay raises are generating, would that solve the majority of these problems? Or are we seeing beyond one category generally?
I think this would solve that issue, and it would certainly give us time to come back if it's not. But currently, under current situation and what we're seeing from a requalification standpoint, I think this would cover us.
Would it still also give them 1 year if they, for example, are category 2 and they still are over category 3, would they still get that 1 year leeway as well to find other housing if they're over the one category up?
Yes.
Okay.
Yes.
And Ted, just context on the discussion on this one, I think everybody on the board, or most of the people on the board, have had comments from either renters or from business owners where, you know, people have declined raises or, not worked overtime or declined promotions, whatever, so that they didn't lose their housing. And so obviously not wanting to punish people for committing to the community and being successful. That's sort of the intent behind this. So, John.
Yeah, I'd agree with that. I think there was some genuine fear out in the community over making too much money, exceeding their income limit. So I'm glad we have this to remove that fear.
Yeah.
I'm supportive of this. I was surprised reading the memo that only 2 people were denied over the 150% limit, and that over the past 4 years, 118 people were approved at 150%. So I understand the anecdotes and what we hear, but it's strange to me that there aren't more cases, and my only concern is if there are unintended consequences to this where it may not be an issue. And I don't know if we have surveys from people that say, I'm stuck, and it's a lot of people that feel they can't make more money. But I was just surprised by how few people were denied or were over the 150% income limit. So is it really an issue?
I can try to speak to that, and Emily might be able to speak to that better, but
I can
think a few
speak
things
to,
are going for us. One, some people just say, I know I'm not going to requalify, and so they're not coming in, and they're trying to figure out where they're going. I I think we've seen that. We've seen Home Track is still a work in progress, and we are still getting data entered in the right manner from a kind of a perspective of those reasons from a requalification standpoint. So there is a potential for some data entry issue. And Emily, do you have anything to add?
Yeah, I'll just add that I think that the other way to look at it is that people know that they can go up to that 150% but not over. So that's what they're doing. And so the data is maybe confirming that people are denying those raises. Or the thing that we don't have data on, right, would be if people are turning down those extra shifts at work. So say there's a nurse at the hospital who works 3 days a week but has the opportunity to fill in a shift which would help the hospital out on a weekend, and they turn it down because then they'd have an overtime shift and that would increase their income. So we don't have that kind of data because people don't tell us, like, I'm turning down shifts at work to stay within my income category. But I think that people are, looking at the 150% and saying, I can only go up to this much, maybe.
How different is the 150% compared to going a category up?
Yeah, so I think it's pretty close.
So we'll have the same problem, the same issue?
I think that the issue is that the 150%, we said you can only do that for a year. So you basically have a year then to look for a new place to live. And what we're saying now is you can do the one category up, which is going to be around 150%, but we're not limiting it to that year.
Okay. But they're still going to stay under that 150% so that they don't have to, they don't have to move
one more
up, right?
category up.
Ish, yeah. So I did include in the packet a table at the end that showed with our current income limits what 150%, 200%, and 250% looks like for you all, because there was those conversations last meeting about going up
Doesn't
to
have
that
the
higher. And I
category.
think when we looked at those numbers, we said those are pretty high incomes. And there was some concern expressed in the community about, like, now if you're really allowing these super high incomes, then the lower income earners are gonna get forced out. So we thought the one category might protect some of the lower income earners while still giving the flexibility to the workers in those units.
And by the way, the scenario where somebody is like, they're right now, the cases that they're thinking they need to move out because they're making too much money isn't necessarily a bad thing, in my opinion. Like, if they're able to find housing now that they're making a lot more money, that's the stepping stone we want to see.
I think the problem is they can't find any housing, and so they leave the valley.
Right. I mean, I would say too, I mean, this is treating renters more like owners in the sense of allowing, at least in this case, some income growth. Right, so then they would, if they wanted to buy something, then they are gonna have to qualify for the higher category. Right.
This goes back to my just interest in what the turnover is in the program, because people will be staying in their units longer in rental, which is great. It's more like ownership. But then the flip side of that coin is there's fewer opportunities for new people to the community, filling the lower wage jobs potentially to get into the program. So.
Okay, thanks, Peter. Christine, anything?
I like this modification to the regulation. I think that answers some of the questions that came up at council. And just a broader note was that maybe, and I know this comes up for this board a lot, but maybe it's time to look at the categories again as a part of a different discussion.
And I would say, so that is on our agenda for, as soon as we were waiting on the affordability study, I believe, and then once we get that, that is one of the things that is on our work plan, is looking at the categories and evaluating whether those still make sense. Ted, Jeffrey?
We support, I don't know, Jeffrey, any?
I'm waiting for the HUD stuff to fire and fury.
Okay.
We are too.
Okay. All right. So then we'll move on to lottery chances, allowing people 1 to 4 years of work history into the lottery.
Okay, so Carson just led it. We are proposing that an additional category be added in the current chances table for how many chances different brackets of employment history get you. And so staff is proposing that there is a category added that is 1 year to 4 yeyears, and then they would get 5 chances, and then everyone else would get an additional chance. On page 12, so if Karen just scrolls down a little bit, you can see the proposed advantage versus the current advantage as well, with the addition of the category up above. Happy to answer any questions.
Just open it up. Who would like to comment on this?
I
Christine?
can give you some
Go ahead.
feedback. We were supportive of this, but council suggested increasing it from 1 to 2
Okay.
as a consensus.
Okay.
At Jackie's suggestion.
Yeah.
That was your idea.
Yep.
That was your idea.
That was Jackie's idea.
I agree with that.
So
Yeah.
Jackie's supportive. Okay. Anybody else? Nope. Okay. We will move on.
Great, staff will make the change to 2 to 4 years before the second reading in April.
So that's good.
The last one is really a clarification of clarifying the priority for ADA APCHA managed rental units, so that it is very clear that if an ADA rental unit becomes available, that the first priority is for an individual that has a disability that is ADA qualified, and then an emergency worker would have priority. So it's really just tightening up the wording on that to make it very clear.
Okay. Any comments on this one? Nope. Okay. So we will move on then to number 6, which is the sex offender criminal policy for APCHA properties.
And I believe Tom is going to handle this one, but if not,
Okay.
and he's taken himself off mute, so that's true. Okay, thank you.
Take it away, Tom.
Okay, so, I'm having a little trouble hearing some of the board members. I don't know if you all have your mics on or not, but.
Can you hear me, Tom?
This, at the last meeting,
Maybe not.
we had a policy discussion about whether or not the board would want to address the issue of sex offenders, those who are registered sex offenders, to be barred from APCHA housing. Unlike a lot of your decisions, this isn't a data-driven issue, it's a policy question. The board gave direction to draft a rule that would preclude Tier 2 and Tier 3 sex offenders from APCHA housing. There are 3 tiers defined by federal law. The Tier 1 is sex offenses where the sentence imposed is less than a year. So Tiers 2 and 3 involve sentences of greater than 1 year. Both of them do. The difference between Tier 2 and Tier 3 is that the Tier 3 offenders include not only a sentence of more than 1 year, but also aggravating circumstances as specified by federal statute. The determinations of whether or not someone is to be put on the list, the list is not up to APCHA. It's the sex offender registries are maintained by the states and territories of the United States. So APCHA's role is pretty much, other than deciding how far to investigate, which may turn out to be pretty objective as well, but the requirement is straightforward. Either you are on the list or you're not. A Tier 2 offender is required to be registered for 25 years, and the Tier 3 is a lifetime sex offender, right? Someone is required to be registered lifetime. So those are the two categories where someone would be prohibited from residing in APCHA housing. This is legislation. This isn't about, obviously this case came up based on a specific situation in Wood Creek that the board is familiar with. We're not addressing here who this applies to in any specific situation. That requires a further action, quasi-judicial action of enforcement, which would follow the normal enforcement procedures in our regulations. We're not involved in that at this time. This is just adopting legislation of general applicability and whether or not the board wants to proceed with this or not. Happy to answer questions. The rule itself is, since it is not complicated, as you can see, it's just a question of are you on the registry or not. So with reference to the federal statute, it's not difficult to, we don't need a complicated rule in the regulations to implement this amendment.
Thank you, Tom.
Bethany, could you talk about how we would apply that rule procedurally?
Well, I should
Bethany's
mention one
muted.
thing.
Okay.
It requires self-reporting, first of all. In other words, an applicant has to identify whether or not they're on the list. Beyond that, APCHA is empowered by the rule to undertake an investigation, and that's Matthew's question, and I'm not really qualified to answer what staff thinks they may want to actually do.
So we, as you can see in the packet, we'd propose running through the system we currently use, Verified First, during either a requalification, a qualification, or if we have some other reason to believe it. But for ownership, we would be asking people in the affidavit to assert that they are complying with this rule. And if we had, so we're not planning on running everybody through every database every year. We'll do it at requalification, qualification, and during the sales process, and then after that, during the affidavit. That's our proposal, and I hope that.
Okay. Jeffrey, fire away.
I'll leave it to Ted. Ted's the primus inter pares at this
Okay.
table.
Well, Jeffrey can support some of these points, but we had a pretty healthy discussion about this yesterday. Not so much about the merits of the idea, but about the ability to apply this in a reasonable way, particularly how accurate are these databases if people have to be forthcoming about their history. Just looking at something like Verified First, is that a reliable source that we can then tell the community we are putting our faith into, that won't come back later to then be pointed out that we didn't do all of the work we could and someone got through the filter, that kind of idea. So I don't know enough about Verified First, if that's the best option, if staff thinks that this would actually be a way to say definitively verify what someone had signed their name to. I don't know if anyone has the answer to that.
Well, Verified First runs it against the existing databases, so you're relying on the accuracy of those databases, which we can't guarantee one way or the other. So AI says Verified First claims a 99.8 total accuracy rate.
And that's across 50 states, so the entire world?
But not the entire world.
Okay.
But the databases it's pinging against, we are relying on those to be up to date.
Sure.
So I can make a couple of comments on that. First of all, unintended error is always a possibility, and that applies to any enforcement that we get involved in, or any review of anyone's qualifications. It's possible that somebody slips through the cracks. This one is more cut and dry, though, than other things. I think, for example, it's going to be a lot easier to determine if somebody's on a sex offender registry than in many cases determining whether somebody makes enough money to qualify for a certain category. But we have to rely on the information sources that are out there, and we can't guarantee that that any of these sources are perfect. But the other part of it is that if we find out after the fact that somebody was on a registry and either didn't accurately represent that fact, well, they would not, if they haven't accurately represented that fact, then you can enforce against that person for fraudulent representation in their application. And that applies now to other issues, such as owning other property, or do you make enough money and where do you make it from, and all that. So we're not bound to live with a mistake if someone has misrepresented their situation. And if it shows up later in public records, then obviously that's what they've done.
Okay, thank you for that. Another concern was generally with this, running criminal background checks on all members who are participating in APCHA, and what that might uncover as well. That's just ancillary to what we're looking for here. And what would that potentially lead to? Is that a slippery slope to be going down that might?
Well, again, we talked about this at the last meeting, and I brought it up that sex offenders aren't the only people who are in the criminal justice system and who have records and who have criminal sentences imposed upon them. It's a judgment call about how far APCHA wants to go. Certainly, you could expand the prohibition to cover criminal offenses, say all felony convictions, if you wanted to. I think we would have to go back to the drawing board to determine, exactly how to say that, because it's not as cut and dried as being on a sex offender registry. You could have had a felony, 40 years ago, or there could have been some sort of plea arrangement that defers judgment on a felony conviction, potential felony conviction. It's more complicated. But at the last meeting, the board said, let's just start with this and leave it at that for now. But you have broad discretion to expand this if you choose to do so.
I don't think that's the goal, but it seems like something that could come up later, not by design of the amendment as it's written. So I guess, do we think that as this is written, this is going to be an effective way to implement this policy, or there are potential, blind spots in it that we aren't currently aware of? Do we like the way it's all written out, that we think this is going to cover it and guarantee that we're getting the desired result from what we're trying to do here?
Well, the policy question, of course, is yours. If the objective is to keep certain registered sex offenders out of the program, this does it without a lot of moving parts on APCHA's part, because it refers to objective criteria, namely the registry. And you're either on it or you're not somewhere. That's basically it. You're on it or you're not.
And just to let you know, staff is a little concerned about having this obligation, just to let you know.
And there's concerns that could be shared that staff has?
It's a very, it's the board's authority, but it's a very big change to the way we've analyzed people situation before, only looking at workforce, at their work in Pitkin County, and staff going to a different aspect of that is difficult. That could raise some difficulties in our interactions with the public, and I don't know, accusations that we're taking things too far and prying. We get enough comments that we are being intrusive and nosy as it is, and this would be a new level of that.
And I would add, so the discussion too, I mean, as Tom said, this would just, right, so we talked about at the last meeting, just the accuracy of how do you go about, we talked about, do we have to run this against everybody who's in APCHA housing now? And, that's not the road we wanted to go down. I think really what this is designed for, and as Tom said, is really the only way you're going to have enforcement on this would be is if you find out somebody wasn't truthful, and then you have, okay, well, you weren't truthful, right? I guess there could one of the things that we do need to discuss is, there could be existing people in APCHA housing that we don't know about, and this would make them ineligible, right?
Yeah, I have to address that. I have not, certainly the rule would apply prospectively to anyone who is applying for APCHA housing. I cannot answer the question about whether it is enforceable retroactively until we get in a situation where that may be the case. There are rules of law that in some cases allow for retrospective application of new laws, and in some circumstances it's prohibited. So I don't think we should make an assumption at this point about how it's going to apply in cases where there may not have been a violation yesterday, but after adopting this rule, there might be. That's an open question. Now, if you want the answer to that before acting on this, I'll do the work. But I can't give you the answer to it right now.
Thank you, Tom. Anybody else, John?
Yeah, I was just going to re-emphasize what Tom already touched on, but the reason this is a reaction to what was obviously going on down in the Woody Creek Trailer Park, and we had public commenters here that spoke at length about this issue, and Tom emphasized to us how difficult it was going to be to search databases for all crimes, and we decided let's just focus on this one because this is what was being presented to us, and that's how we got here. I think we should move this forward.
Any other comments?
Yeah, I just have a couple questions. Okay, so first with the $30 screening, that is going to be at the time of application for a new purchase.
Yes.
So does that mean the application fee is going to increase?
It'll be a separate fee, but part of the overall package. Yeah.
So effectively, it's $30 per person.
Right.
And that, okay.
Certainly.
Also, so it talks about owning the property and having a renter. The situation in Woody Creek was neither. This is a child of the owner, so he's not on title of the property, and he does not have a lease. How does that get applied?
It's a member of the household.
Yes.
Member of the household?
Yeah.
Okay.
And again, that's going to be a question that might be different in different cases because the deed restrictions are not the same. They're not uniform on all of it, but the way this is written, it applies to anyone in the household, which is the broadest term we have to apply the rule. A tenant is a member of the household. A roommate is a member of the household. A family member, a child, a uncle, a dependent, aged parent is a member of the household. So it applies broadly to all persons who actually reside there. That's the way it's written.
Well, and I guess to the retroactive piece that I know is open-ended, in this particular situation, right, this person, this child, was living in the household, is now back in jail. If that person comes out of jail and goes back, is that considered retroactive? Or is that from that point forward?
I'm not gonna, as I say, this is legislation that you're considering. If the outcome of that case specific case is determinative, which I don't think it should be, it was just a policy question. I'll look into that, but it's really, I can't tell you right now, how that situation, would be affected by this rule, because as you say, among other things, the person at issue is incarcerated, and what's gonna happen after that, we don't know. So I just don't wanna speculate at this point on whether the rule would apply to the Henleys or not. They would, I assume, assert that retrospective application law to them is illegal. For purposes of this proposed rule, I don't think we need to go there, and I don't think we should.
Thank you, Tom. Jeffrey?
So in yesterday's work session with Matthew, a majority of the Board of County Commissioners did not look to move this piece of legislation forward. So if this comes forward at first read, we would respect that you would pull number 6 from the resolution or request.
Okay. Okay.
Council, we brought this to council. Council was supportive of it. We didn't have this exact language, but everyone was in support of moving some policy forward on this.
Peter?
No comment.
Okay, any other discussion on this? Or would somebody like to make a motion? I know the one change that we did talk about was number 4, lottery chances, altering that one from more than 1 year, less than 4, to more than 2 years, less than 4. I don't think there were any other changes.
You do have the recommendation down there.
There's a
if anybody
recommendation
wants
at the
to make
bottom of
that.
page 13 if anybody would like to make a motion.
And then just to let you know, and then what will happen is at second reading in April, it is public comment. And there's no requirement to take public comment at first reading. Public comment usually comes at the second reading and the actual public hearing.
And at second reading, you can still make changes.
Yeah.
You're only required to go to another hearing after second reading if the changes are so substantial that it didn't put people on notice, but ordinarily you can make adjustments at second reading.
I would request to the board chair that we pull number 6 and that you vote separately on 1 through 5 and number 6. So Pitkin could at least vote in opposition to number 6, but support 1 through 5.
How does that work from a procedural standpoint? Does that, if we separate these into 2, does that trigger us to go back to notice?
No.
No, you can have a motion now to approve all or any portion of it. You can do them all separately, do them all together, or
Great.
anything in between. It's
Okay, so we have a
perfectly
motion.
legitimate procedurally.
We have a motion to separate 1 through 5 as one vote and 6 as its own separate vote.
I'll second.
Second from
Who
John.
made the motion?
Jeffrey made the motion.
Jeffrey is an alternate.
So
Ted made the
Yeah, I'd like to make a motion.
Ted would like to make a motion. Okay, and John second Ted's motion, and that is a roll call vote.
This is from 1 through 5.
This is this is the motion to separate them, and then we'll have a motion.
Okay.
Yeah.
So Jackie? Carson?
Yes.
John?
Yes.
Peter?
Yes.
And Ted?
Yes.
Okay, so we will separate them into 2 votes. Someone like to make a motion on 1 through 5 with the amendment on 4 to 2 years, but less than 4 for entering the lottery.
So moved.
Okay, motion from John,
Okay, second?
second from Jackie.
Okay,
Okay, roll call vote.
okay. Jackie? Yes. Carson?
Yes.
John?
Yes.
Peter?
Yes.
And Ted?
Yes.
Motion carries, and then now we have the vote specifically on the sex offender criminal policy for APCHA properties by itself. Is there a motion to move that forward?
So moved.
Who made that?
John.
John? Okay.
Motion from John, second from Jackie, and is roll call.
Okay. Jackie? Yes. Carson?
Yes.
John?
Yes.
Peter?
Yes.
And Ted?
No.
Okay, that will move, both, all 6 items will move forward to April 15th for public hearing. Okay.
Thank you.
Chris, come on up. So we have, this is approval of resolution number 3, series of 2026 for the Lumberyard development. Tom, did you have something?
Yes, Carson, just briefly to introduce this and then turn it over to Chris, who's, of course, much more knowledgeable about the project than I am. But just a brief legal introduction. This agreement is to make APCHA a special member of the LLC that is going to be the operator of the project. It's unrelated to APCHA's regulatory role, or it's not directly related to APCHA's regulatory role in terms of the enforcing the APCHA regulations. It's a proposal to include APCHA in the entity to help facilitate the project, and it does not place any financial demands upon APCHA as a result of this the inclusion of this status relative to the project. So just so you know those things, and as to more details, I turn it over to Chris.
Thanks, Tom. Chris, go ahead.
Thank you, Tom. Thank you, Carson. Which way is on?
Red
This
is
way?
on.
Red is on.
I think that's
Opposite.
it.
Yeah.
Opposite of
Okay.
City Council.
Yeah.
Thank you, members of the board and staff, for having us here today. I am Chris Everson, Affordable Housing Development Project Manager with the City of Aspen. And do you want to introduce yourself?
Hi, I'm Kimball Kringle with Gorman and Company, the developer of Lumberyard.
Yeah, I'm going to go ahead and share my screen real quick, if that's okay. Just to start by bringing up the Cindy's memo. So thank you, Tom. Tom put it well. The city of Aspen is requesting, as we have before on similar rental projects, where the Housing Authority become a special limited partner of the operating entity for the rental operation. to gain the benefits of tax exemption for the operation. The tax exemption allows the facilities to operate with lower expenses, of course, and with, of course, limited deed-restricted rents. That is super helpful for being able to operate the facilities. So Tom put it very well. And Kimball, if you want to expound at all.
Hi. That's generally a great overview. In deeply affordable rental housing projects, property taxes could really sink what the debt carrying capacity is, and just honestly the operational sustainability of these assets. So it's very common in Colorado through our statutory procedures to allow housing authorities to enter into these agreements to bring that property tax exemption benefit to the property to encourage better sustainability overall through management.
So, as Tom mentioned, there really are no liabilities to APCHA for this.
Tom's got his hand up.
Sorry,
Tom,
go ahead, Tom.
did you have something?
Just to make one other comment, the resolution would also authorize Carson to execute additional documents that may be necessary to implement APCHA's status as a special member of the LLC.
Thank you, Tom.
Can I ask just curious what the property tax revenue would be from a 277 unit?
I have never run that estimation, mainly because I knew it would be
Exempt?
It would sink the ship. So, yeah.
So I just went ahead and popped on the screen what the membership would be of the operating entity. It's relevant that the city is owning nearly 95% of the operating entity. APCHA's interest is merely 0.01%. And so there are really no financial liabilities to APCHA related to this action. Any questions?
I don't think so. I mean, I would just, I would just make the comment. I've been on the board for quite a while, and there have been other projects where APCHA has been asked to do this same sort of setup, and APCHA's done it several times. And I would just note that this project, as Chris said, it brings a lot more to the table than previous projects, in that it's not relying on APCHA and APCHA staff for the day-to-day management of qualifications, of general enforcement. APCHA would still ultimately maintain the ability to enforce, but it really does. It's not adding the burden to staff of an extra 277 units, rental units, that are going to have lots of requalifications and just sort of ongoing staff time. And so this is not, it's not adding any burden to staff.
Can I just ask, while we're talking about that, then Gorman can choose whoever you want to live in the units.
No. Gorman will apply APCHA regulations.
But how is it different from Castle Ridge or Centennial?
It's a lot different. But they can explain this, and it's actually in the document as to how these are going to be filled.
Okay.
And there's also a priority system that the city has provided as well as to who's chosen for these. So, but we've been talking about this for a long time. It's totally different than Centennial and Castle Ridge.
Mm-hmm. Okay.
As to how they're going to be filled.
Sorry. I'm trying to bring up a picture of it for you. This is a slide that we discussed here either February 18th or before that, back in January. So Kimball and myself have been working with the staff and with Tom. The facility will have 100% APCHA deed restrictions on all 277 units. I should mention that this first phase is the first building. It's 104 units. So there'll be another phase that will be here, seeking a similar request next year when we have another closing. So I should mention that the City Council is teed up for March 24th, next Tuesday, to consider a large set of 7 different agreements with Gorman for approval that would, for this phase of the project, be putting in about $120 million of the city's affordable housing funds to fund this effort. Gorman is also bringing additional funding to the project as well for this phase. But like I said, 100% APCHA deed restrictions. The tenants must qualify per the APCHA regulations, and the developer operator will be performing all of these actions. They came to the table with a very flexible approach. They said that they were willing to take on all of the administration or share some of the administration with APCHA. And in fact, a lot of the administration through our collaborative process is landing with the developer's operation. So the leasing will all be based on APCHA incomes and rents. The tenant selection will be via lottery for all of the units, both at the initial lease up and for unit turnover in the future. The City Council has, and I should have mentioned this before, the City Council has put in place certain priorities for that lottery, which we've reviewed here before. But they did, on March 9th, discuss the addition of the owner transfer priority, which you all requested, amenable to that. And on March 24th, they will also be considering a resolution to modify the priorities to include that owner transfer. So that is already going on the ticket. So Gorman will also be doing all of the advertising, the lottery application, the lottery process, the qualification of the lottery winners, all the leasing, the property management, all the enforcing of the regulations. APCHA will have access to all of the qualification docs for auditing purposes. And APCHA does retain the final tenant qualification authority, even though operationally they will be handing that off to Kimball's organization. One question that came up about that was, well, how are you going to implement that? And we do plan to begin occupancy of the facilities in 2028. And before that, they want to make sure that everybody's trained in exactly how to qualify tenants based on the regulations and the related nuances. So I hope that answers some of those questions.
Tom, did you have something? I saw your hand up.
I was just going to say, in response to one of the comments that preceded what Chris has just presented, Gorman is going to be, well, the city is requiring a deed restriction to make sure that the tenants have to fully comply with all of APCHA's regulations. And APCHA, we're in the process now of we're almost at the end of negotiating that deed restriction, and APCHA will be the beneficiary and have the right of enforcement.
Thank you.
That deed restriction refers at length to the APCHA regulations.
Great. Any other questions or discussion on this? There's a motion on the bottom of page 85.
I'm just curious, we recommended, I saw the council discuss the prioritization that we recommended that anyone from ownership be their 10 units set aside in the Lumberyard as priority. And so that, I thought there were some good comments made by the council, but that's we're done with that, right? We can't revisit it? Just curious.
Well, ultimately, I mean, council has the final say.
Council has the final say, so we made that recommendation.
We made a
now that
recommendation,
second
and
reading.
it's in
Okay.
council's hands. Yeah.
Great, thank you.
Somebody like to make a motion?
I can't.
It's on the bottom of the, yeah.
Yeah. Yep.
Second Amendment and reinstate operation agreement for the Lumberyard.
Mike.
Oh, sorry. I motion to approve the addendum to the Second Amendment amended and reinstated operation agreement of Lumberyard Apartments 1 LLC.
That's
Actually, the motion should be to approve resolution.
Resolution
number
Okay,
three.
sorry, I was reading the bolded. I motion to approve Resolution 3.
Okay. We have a motion to approve resolution number 3, approving the addendum to second amended and restated operating agreement of the Lumberyard Apartments 1 LLC. Is there a second?
Second.
Second from Ted. Thank you. And it is a roll call vote.
Okay. Jackie.
Yes.
Carson.
Yes.
John.
Yes.
Peter.
Yes.
And Ted.
Yes.
Thank you.
Motion carries. Thank you.
Okay. Any other questions while we're here? Okay. Thanks.
Thank you.
All right, we will move to the last item on our agenda, which is the HOA Capital Reserve Study Reimbursement Program. And we've got Emily here.
Hi, Emily Maynard, APCHA's Housing Policy Analyst, and I apologize, in the memo that I sent, I realized I should have included a little bit of background for our newer board members, but in case you all didn't know, last year APCHA paid for capital reserve studies for 27 of 50 eligible majority multifamily APCHA HOAs. At the last meeting, Carson asked that APCHA do another round of paying for capital reserve studies, and sort of before I went down that road, I wanted to throw this out here and gauge board interest on if we could do some sort of standing program for reimbursing for these studies for APCHA HOAs. So that is what I'm here to talk to you all about, see if you are interested in that, or if you want me to go the route that Carson suggested, which would be another round of studies. I will just say I think my impression would be that doing another round so soon we wouldn't get that many. So you might also want to consider, like, how many would you hope to get, and if that would be worth it, or if this proposal of us just having a standing program is of interest to you. I laid out some ideas of what that could look like and would take your discussion and recommendations on that.
Okay. Yeah, so I mean, I'll jump in. As Emily said, we did a round of HOA capital reserve studies, and we pooled them all together and had one firm that came in and did a bunch of them for a bunch of people. I think there were some delays in doing it. It took a long time,
Yeah.
and I think that by doing that, we were able to set specific parameters that we did want included in all of the different capital reserve studies. And so I think we got pretty decent participation in that. But I think in just looking at the people who didn't participate and why they didn't, I know there have been a few people that have regretted that and said, well, we should have done it, or we just missed it, or whatever. So that's sort of the background for this. Anybody, any thoughts on this?
So in a typical HOA, they would budget to have look at their reserves every few years. And we think that HOAs are just not doing that because of the $5,000 cost. They're foregoing it, and if we offered that benefit, they would do it, and they would share that information with us.
Well, I mean, I think that a lot of the discussions we've had, there have been due to, insurance is a big one that, right, we've had increasing expenses to HOAs. And, one of the easy things that is easy to drop off in an association that doesn't have a professional manager, right? So any association that has a professional management, that manager is going to have fiduciary duty to make sure that they're completing a reserve study on a regular basis so that they can adequately make sure the HOA is reserving for those. So this would apply to anybody who doesn't have professional management. And I think the thought process is, with this one, I think this is a great suggestion of just allowing, sort of one-off budget, 10 a year or whatever the number ends up being, but just allowing a tool maybe for an HOA that doesn't, that's tight on, if you have an HOA and you're tight on your reserves already and you're increasing dues already and you have membership that maybe doesn't want, further increases, this is, I think, a tool that would help them at least identify the shortcomings in any capital repairs that they may have within their project. So I'm supportive of this, but, feel free to jump in. John?
I definitely support it. I think any time we can remove financial barriers from HOAs, knowing that their capital reserves are in the state they're in, I think that's what we should be doing.
I would say I'm totally in support of it as well. My only question would be, well, first, there's 50 units that are not professionally managed. Is that 50 number is the non-professionally managed
No, they
ones?
could, so the
any
professional,
of them?
yeah, I mean, so we do know that, I think by count, we only had about 25% of the number of units. But there was, how many, there's what, 80-something HOAs roughly?
Yeah, depending how you count it.
Yeah, so depending on how you count it, there's roughly 80-something HOAs. We had about 50 participate, but that only is 20% of the total count of the units because you've got the Centennials, you've got the Burlingames,
You have the big
Gotcha,
ones
that are managed
Hunter
professionally.
Creek, that are, they have professional management. So
And I can talk to that too. When the who the APCHA board, I wasn't here when these decisions were made, but when we paid for the studies last year, the way they decided who would qualify to have APCHA pay for these studies for them was majority deed restricted multifamily HOAs. So that excluded a lot of the HOAs like Aspen Village, Lazy Glen, that are, single family homes, or where their HOA, their expenses might just be roads, and the property itself is basically the owner manages the repairs for that. So you all can determine, who you would want to qualify for this program. I just used the 50 because that's what we did last year. So you all can discuss and say any APCHA HOA, or we want to stick with the multifamily or whatnot. So that's where the 50 came from, because it's what we did last year, more or less.
I would just say, I think it's a great idea and I'm in support of it. I would just say, I think that we need to make sure we're educating these smaller HOAs on the benefit of it, because I think there's a lot of fear that, because I have heard people say they don't want the reserve studies done because they think that means their dues are going to go up. So you want to make sure they understand what your point is you just want to make sure you're allocating properly and you don't have super high dues, but the dues are being put in the right buckets. And the consequences of not having proper reserves and deferred maintenance and how that can play out in the long run and ultimately cost them all more money. So I just think as long as we're educating the HOAs to try to get those other ones to participate, but I think, yes, I think it's a great plan.
Yeah, great point. Thanks.
And I think a lot of that is buyer education, right? And making sure the buyers understand if you're buying into an HOA that has not done a capital reserve study. I mean, it's you buy a house in a condo association and they hand you a budget, and that means nothing because you don't know what's there. I mean, it's just numbers on a page. But I think that if the buyers understand the importance of that, I think it's fair that buyers understand what they're, and I think APCHA, that's something APCHA should be doing, is telling buyers, making sure they understand that piece. So I'm hearing General Jeffrey, do you have?
I just have one sort of weed comment,
Okay.
and you can discount it at that. That if one of the struggles of an HOA is going to be insurability, and so actually doing a reserve study on top of a wildfire assessment may improve their insurability, and specifically not only the capital reserve, but also, and this is why it's weeds, they should be saying, what are we doing to retrofit the entire structure in order to get insurance? So appreciate the funding for the capital reserve study, but to me, insurability is going to be a larger issue going forward.
That is an excellent point for our
Because
HOA.
It's not in the bullets of what's covered.
The education series.
For our HOA education series, that is an excellent point, because I don't think people often think that this may actually reduce your insurance.
I actually met with an insurance broker this week, and we were having a lot of discussions on education series. He does a lot of APCHA insurance, and he's always having to remind people that you have to insure for the replacement cost, not the maximum sales price. And that's a continual struggle, so we need and he's going to be talking to Emily and Meg about this kind of idea to how we can really stress that to the APCHA owners, what they need to do.
Sorry, and I guess it's not a weed comment. We do have a new statewide minimum code for wildfire that will apply to each of these HOAs, so that the studies that you did last year are also outmoded at this point, given the replacement cost is likely going to be higher for wildfire-resistant materials.
Excellent point.
Is there somebody we should get Is there somebody we can get a hold of that we might be able to bring in to do a class or an educational thing for ours? If you can provide that to me, that would be great.
Happy to.
Okay.
Where does the 50,000 come from every year?
That is a great question, Peter. And I would need to sit down with Sandra and look at our budget and see if APCHA has the 50,000 to budget for this next year. And if she tells me no, APCHA does not have that money, then I would need to go and ask the BOCC or City Council or both if they would be willing to fund the program. So I'm coming to you to gauge interest first without having talked to Sandra about APCHA's budget.
Okay.
So that would be my next step, would to see what APCHA has and can budget for next year for a program like this. Yeah, and we can change the details of what I've proposed if you'd like as well. I used numbers from the reservist who did the studies last year as to what he predicted each HOA's reserve would cost, and his general was 3,000 to 6,000 per HOA, so I settled at 5,000 was the max that we would reimburse. If you guys are okay with that, that's how I kind of landed on the 50,000, 10 a year as a budgeting tool. But if you want to change that, I can also change that before I look at those things.
I think that makes sense.
I would consider or suggest opening it up to some of the single-family HOAs too, because why not?
Yeah, I think that.
To say that if
like, so I might specifically like the mobile home parks, but if they want to take advantage of this as well.
And so, I mean, is that an inspection then, if it's just on a house, or?
Well, no, you have common interest areas, and so you
common
put in
areas,
capital
okay.
reserves for roads, electric, everything, and some of those developments.
And what about the requirement to share the information? Because if we see these reserve studies say they're underfunded and they don't raise their dues, then I don't know, where does that all lead? Was it worthwhile to find out something they're not able to
When we
address?
did the last round, we were very clear with the HOAs that staff might see it, but when they weren't going to be publicly projected, so it would be it would be an information session, not we wouldn't be using that in any kind of
And would
public
buyers-
shaming.
Will buyers have access to that, to Carson's point? Like, if they do this reserve study, are
Yeah.
they then obligated to give it to buyers?
And that's just part of the normal HOA process, yeah. I mean, if they request the HOA documents, yes.
Okay.
Well, and can I jump in on that? A lender will see it.
Yeah, yeah.
If it's part of the questions, if you're getting a mortgage on a condo, period, there are Fannie Mae questions, and they ask that regardless of if they know you have it or not. They ask the management company to complete a questionnaire. That's one of the questions.
Mm-hmm.
Have you had a reserve study? If the answer is yes, they often want to see a copy of it, and then there's specific questions based on what it found. Did it find deferred maintenance, things like that. So if it does find those things,
That's
the
out
bank
there,
isn't
yeah.
gonna, a Fannie Mae, Freddie Mac investor will not, they'll step away from the project.
One more reason to do it. Increases the lendability of your property. Okay, so sounds like
Great, thank you
direction to
all.
move forward.
Yep.
Thanks, Emily.
Thanks.
Okay, that concludes our agenda. Is there a motion to adjourn?
So moved.
John? Second with Jackie.
I'm going to start at the other end. Ted,
Aye.
Peter,
Aye.
John,
Yep.
Carson.
Yes.
And Jackie.
Yes.
Meeting adjourned, 5:39.
You have stuff for me to sign?